I'm Rob Sterne, founding director of intellectual property law firm Sterne, Kessler, Goldstein Fox. Today, I want to talk to you about a critical topic in the current Patent Office litigation landscape: claim amendments in post-grant proceedings after the America Invents Act. Now, it is very important to know that claims can be narrowed in these new contested proceedings, whether it be an inter-party review, covered business method review, or a future post-grant review for AIA patents. However, unlike the prior re-examination process, where a party was allowed to narrow their claims, but there was no real limit to the number of claims that could be added during the re-examination process, the Patent Trial and Appeal Board, in their trial practice guide and in their rules, has limited the number of claims that can be amended. The basic rule of thumb is a one-to-one correspondence between the existing claims and the new claims that can be amended. In addition, the claims can only be narrowed in these post-grant review processes. And the board may be very strict in how these claims can be narrowed, so as to require that all of the words that are in the original claim be included in the new amended, albeit narrower, claim that is added during the process. Now, the decision to amend claims is made at the very beginning of the process, around the time that the trial institution decision is rendered by the board. So a party who is the patent owner needs to be considering whether claim amendment is warranted in these proceedings. And of course, if there is parallel litigation involved, this is a very critical issue for many reasons, including loss of past damages. Now, once the decision is made to amend claims, the question becomes, is this a final decision, or could it be done on a conditional basis? In other words, could a party who is the patent owner proffer a claim construction, a claim amendment rather, to the adopted claim construction that would be narrower to the claims that are in the proceeding, but only have those claims considered if the board decides that the existing claims are not patentable over the proceedings in the trial? And the answer to that is yes. A conditional decision can be made by the patent owner so that the amended claims are only adopted by the board if the board determines that the existing claims are not patentable in the trial. And one other question that is arising already is whether this conditional amendment of claims can be linked to a possible termination of the proceeding based on a settlement proposal. And this has not yet been ruled on by the board, but one that obviously comes up in many settlement discussions. Thank you very much.